We steal it off of Aaron's desk. Because the DA's office can't steal anymore.
You know, we come this long way technology wise, but still can't stand.
All right, Mr. Pam, can you see and hear me okay?
Yes, Your Honor.
You're ready, officers.
Jamie Marie Nash.
Nash. All right, this is cause number CR 22-366, Sacred Jamie Marie Nash. Motion to revoke, is this a plea today?
It is, Judge.
All right, Ms. Nash, if you will raise your right hand, I'm going to place you under oath. You swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, you can lower your hand. All right, get back here. All right, Ms. Nash, you were appearing before the court back on June 29th of this year. You pled guilty to a third-degree felony offense, possession of a controlled substance. Court followed a plea agreement that you reached with the state. The court placed you on 4 years. Court sentenced you to 4 years in prison, suspended that, placed you on 3 years community supervision. It's been during that period that the state has filed its motion to revoke your community supervision on September 6, 2023. Honorable Richard Schmidt was appointed to represent you after your filing of indigency. You feel like you've had enough time to talk to Mr. Schmidt, your attorney, about this case, and that you understand everything that you've read and signed today in your plea agreement?
Yes, sir.
Mr. Schmidt, do you believe Ms. Nash to be competent?
I do.
And I see here that the proposed plea is that she would plead true, I'm assuming to all counts, and that her community supervision upon that plea would be revoked. She'd be sentenced to 3 years in prison with a balance of the financial obligations, with her receiving 231 days credit towards that sentence. Is that correct?
Yes, sir.
Right. Ms. Nash, this time I'm going to ask you I'm sorry, Mr. Schmidt, does your client waive the formal reading of the state's motion to revoke?
We do waive, Joe.
She does intend to plead true to all counts alleged.
Yes, sir.
All right, Ms. Nash, how do you plead to counts 1 through 5 in that motion? Are those counts true or not true?
True.
You're telling me that they're true because in fact it is true. You're not just saying that to get a certain plea agreement. Is that correct?
Yes, sir, it's true.
Court will accept Ms. Nash's plea of true to each count as alleged. Ms. Nash, no one's threatened you, forced you, or pressured you to plead true to any of these counts. Is that right?
Yes, sir.
Mr. Schmidt, any objection to the admission of the defendant's waiver of rights to plead true to evidence?
No objection.
That is admitted. The court takes judicial notice of the defendant's judicial question. Is there anything further from the state?
Nothing further, Your Honor.
From the defense?
No, sir.
All right, and based on the evidence before the court finds that Ms. Nash has violated the terms and conditions of her community supervision. Court will follow the plea agreement reached with the state today. Court hereby revokes Ms. Nash's community supervision, assesses her punishment at 3 years confinement at Texas Department of Criminal Justice, orders her to pay the balance of her financial obligations, including fines, court costs, and reimbursement fees. And the court awards Ms. Nash 231 days credit. Towards her sentence for the time that she has spent in jail on this case. Ms. Nash, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you do get released from prison, I want you to report back to the Van Zandt County Courthouse and talk to them about making a payment plan with your fines, court costs, and other fees. Do you understand?
Yes, sir.
Good luck. Step over to the deputy. Who's next, Mr. Schmidt?
Brian Anthony Morris.
Ron Anthony Morris, CR 14-420. All right, Mr. Morris, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thanks, sir. Lower your hand. Mr. Morris, you are appointed Mr. Schmidt as your attorney. Are you pleased with his representation of you?
Yes, sir.
Like you've had enough time to talk with him about this motion to revoke this filed against you?
Yes, sir.
You understand everything that you read and signed as part of your plea agreement?
Yes, sir.
I see here that you're going to plead true today to some counts alleged. Looks like they've alleged upwards of 7 counts, and it looks like the plea agreement is that today, upon your plea of true, the state's recommending that the court find those to be true, revoke your community supervision, assess your punishment in 5 years confinement in TPC, and order you to pay the balance of the previously imposed fines, court costs, and restitution, with you receiving a credit on your sentence for time that you already spent in jail of 1,337 days. Is that correct?
Yes, sir.
All right, Mr. Schmidt, do you believe that Mr. Morris is competent to enter into this plea agreement today?
I do.
Does he waive the formal reading of the state's motion?
Yes, sir.
Does he accept to be true to all 7 counts?
Yes, sir.
All right, Mr. Morris, how do you plead to counts 1 through 7 as contained in the motion? Are those true or not true?
True.
You're telling me that they're true because of the fact what is alleged is true. You're not just saying that to get a certain plea agreement. Is that right?
Yes, sir.
Court will accept Mr. Morris's plea of true to each count as alleged in the state's motion. And court takes judicial notice of his pleas of truth. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights to plea of truth?
No objection.
That is admitted, and the court takes judicial notice of the judicial confessions. Anything further from the state?
Nothing further, Your Honor.
Any further from the defense, Mr. Schmidt?
No, sir.
All right, then, based on the evidence, the court finds that Mr. Morris has violated the terms and conditions of this community supervision. The court of the state will follow the plea agreement reached with the state. The court revokes community supervision, assesses punishment today at 5 years confinement in the Texas Department of Criminal Justice, orders Mr. Morris to pay the balance of his previously imposed fines, court costs, and restitution, and the court awards Mr. Morris credit time of 1,337 days towards his sentence. Mr. Morris, when you are released from custody, please report to the Van Zandt County Courthouse to make arrangements to discharge of your fines, court costs, and reimbursement fees. Failure to satisfy those may result in the county issuing a warrant for your arrest, and picking you back up and going back to the civil process. Do you understand?
Yes, sir.
When you get out, if you'll just report, let them know you can pay that. We'll make some arrangements with you, okay?
Thank you, sir.
You're welcome. Step over to the deputy and move you. Who's next?
Jeremy Hester.
Jeremy Wayne Hester, CR 21291. Mr. Hester, if you'll raise your right hand, Commissioner Code. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your. So your name is Jeremy Wayne Hester, correct?
Yes, sir.
Mr. Hester, are you a United States citizen who reads, writes? Sorry, I couldn't hear you. Are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
You're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt's representation?
Yes, sir.
You feel like you've had enough time to talk with him about your case, that you have had all your legal questions answered, and that furthermore, you understand everything about your plea agreement, what you've read and what you've signed?
Yes, sir.
Mr. Schmidt, do you believe Mr. Hester to be confident, and if so, that he's entering into this plea agreement intentionally, knowingly, and voluntarily?
Yes, sir, I do. On both counts.
Mr. Hester, you are charged by indictment with a third-degree felony offense of evading arrest or detention with a vehicle that does carry a range of punishment if convicted and sentenced of not less than 2 years in prison or more than 10 years in prison, and carries a potential fine up to $10,000. I see the plea agreement in your case, is that you would plead guilty to that charge. In exchange, the state's recommending that your punishment be assessed today at 10 years confinement in prison with a fine of $1,000 plus court costs and reimbursement fees, and you would receive 228 days credit towards your sentence for time that you've already spent in jail. Is that your understanding of the plea agreement?
Sure.
Understanding the plea agreement, I've admonished you about the range of punishment. Mr. Hester, how do you plead to evading arrest or detention with a vehicle? Say what? It's audio issue on my end, but I've heard you say guilty. All right, the court accepts the defendant's plea of guilty at this time. Mr. Hester, no one's threatened, forced, or pressured you correct to plead guilty.
No, sir.
Mr. Schmidt, any objections to the stipulation of evidence supporting the plea?
No, sir, no objection.
All right, the stipulation is submitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
No, sir.
All right, based on the pleas of true and the evidence before the court finds that, I'm sorry, it's not a plea of truth, but based on the plea of guilt and the stipulation of evidence, the court finds that Mr. Hester has committed the offense of evading arrest or detention with a vehicle. The court will follow the plea agreement today. The court convicts Mr. Hester, sentences him to 10 years confinement. The Texas Department of Criminal Justice Institutional Division assesses a $1,000 fine. And the court also imposes court costs of $290 and reimbursement fees of $210. If I didn't say fine, the fine is $1,000, with Mr. Hester receiving a jail time credit of 228 days. Mr. Hester, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Have you step over the deputy?
Oh, fine. Your Honor, while Mr. Manning is finishing up, on Joshua Delbert. He has requested a court-appointed attorney. He's filled out the paperwork and he qualifies for one. So I'm going to appoint Mr. Manning.
Okay, I'll know how to.
And it's a motion to revoke. I'm fixing to give you a reset.
Yes, well.
So you want it on the 30th?
Yes.
He said it would be a contested docket, so the January 30th.
Anyway,
Yes, sir. Thank you. And Mr. Manning is ready now.
who's first?
On Miss Allen.
Miss Allen, Billy Allen.
All right, Billy Dean Allen, cause number CR 21-318. All right, Ms. Allen, if you will raise your right hand now, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you for voting. Ms. Allen, you appeared before the court on November 30th, 2021. You pled guilty to the second-degree felony offense of aggravated assault with a deadly weapon. The court heard the evidence that day, found that there was enough evidence to convict you, and the court followed a plea agreement that you and the state of Texas reached. The court deferred a finding of guilt, did not convict you on that date, but placed you on 2 years of community supervision. In addition to that, you came before the court and requested an extension of your community supervision for 6 months, and the court granted that. During August of this year, the state filed its motion to adjudicate, and they have alleged for appears to be 6 separate counts of violations. Have you had enough time to review this motion with your attorney, Mr. Jonathan Manning? And are you pleased with Mr. Manning and the work that he's done for you?
I am.
Like you've had enough time to talk with him about this motion, that you understand, that you've got answers to all of your legal questions, and that you understand everything that you've read and signed today.
Yes.
All right, Mr. Manning, do you believe Ms. Allen to be competent?
I do, Judge.
And does she waive the reading of the motion to adjudicate?
She does.
Does she intend to plead true to all 6 counts as alleged?
Yes, Judge.
All right, and I see the plea agreement today for you, Ms. Allen, is that upon your plea of true, the state's recommending that your community supervision be revoked, that your sentence be assessed today at 4 years confinement in the Texas Department of Criminal Justice, with you being ordered to pay your previously imposed balances on fines, court costs, reimbursement fees, and you would receive 142 days credit towards your sentence for time that you have spent in jail. Is that your understanding, Ms. Allen?
Yes, sir.
All right. Ms. Allen, understanding the plea agreement, let me ask you at this time, how do you plead to counts 1 through 6 in the state's motion? Are those counts alleged true or not true?
True.
You're telling me that they're true because of the fact they are true. You're not telling me that they're true just so you can get a plea agreement. Is that right?
That's right. True.
All right. Court will, and no one's threatened, forced, or pressured you to plead true to any of these counts. Is that also correct?
That's correct.
All right, then the court will accept the defendant's plea of true to each of these 6 counts. Mr. Manning, any objection to the admission of the defendant's waiver of rights to plea of true to evidence?
No objection to state's offer.
All right, that is admitted in evidence, and the court takes judicial notice of Ms. Allen's pleas of truth. Anything further from the state?
Nothing further, Your Honor.
From the defense?
That's from defense.
All right, based on the evidence before the court finds that Ms. Allen has violated the terms of her community supervision. Court, on that finding of true, will follow the plea agreement reached between the defendant and the state. Court adjudicates Ms. Allen's guilt, convicts her of aggravated assault with a deadly weapon, a second-degree felony. The court assesses her punishment today at 4 years confinement in the Texas Department of Criminal Justice. The court also orders her to pay the balance of her financial obligations, including balances on fines, court costs, and reimbursement fees, and awards her 142 days credit towards her sentence for time that she's already spent in jail on this cause. Ms. Allen, once you are released from TDC, it's important that you report to the courthouse and talk about making a payment plan arrangement to discharge the things that you owe the county. Failure to do so will result in the county issuing more for your rest. Understand?
Yes, sir.
Okay. All right, you hereby remain into the custody of the sheriff, so he can carry out the terms and conditions of the sentence. Please step over with the deputy to begin. Next, Mr. Manning.
Judge, ready on Mr. Douglas Paniagua.
All right, Mr. Paniagua, if you'll come forward, this is cause number CR 22245. Go ahead, Mr. Manning.
Judge, we received an offer from the state yesterday, and my client intends to take that offer. That will be for time, and so we request to be set on the December 14th docket.
All right, court will set Mr. Paniagua for plea before the court on December 14th. One.
Judge, next ready on Mr. Justin Ryan Mosley.
All right, Mr. Mosley, if you'll come forward, this is cause number CR 21-86. Mr. Mosley, sir, raise your right hand. I'm gonna place you under oath. Mr. Mosley, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. All right, Mr. Mosley, your name is Justin Ryan Mosley, correct?
Yes.
And Mr. Mosley, are you a United States citizen who reads, writes, and speaks English?
Yes, Your Honor.
Have you ever been diagnosed with any type of mental condition?
No, sir.
You're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning's work for you?
Yes, sir.
You feel like you've had enough time to talk with him about this case, you've had all of your legal questions answered, and you understand everything that you've read and signed today in this plea agreement?
Yes, sir.
Mr. Manning, do you believe Mr. Mosley to be competent?
I do, Judge.
You explained to him this plea agreement and his rights pertaining thereto.
I have.
I see that the plea agreement in this case is that Mr. Mosley would plead guilty to attempted aggravated assault with a deadly weapon, third-degree felony. And the recommendation is that his punishment, that he be convicted of that offense, that his punishment be 4 years confinement in prison with a $100 fine. States abandoning its punishment enhancement. That in addition, there would be court costs, reimbursement fees, and Mr. Mosley would receive 1,069 days jail time credit towards his sentence for the time that he has spent in jail on this cause. Is that correct?
That is correct, Judge.
All right, Mr. Mosley, I have to tell you that the range of punishment for a third-degree felony, attempted aggravated assault with a deadly weapon, is no less than 2 years in prison or more than 10 years in prison, and a fine not to exceed $10,000. Understanding the plea agreement, understanding the range of punishment, Mr. Mosley, how do you plead to attempted and aggravated assault with a deadly weapon? Are you guilty or not guilty?
Guilty.
And are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, Your Honor.
Has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
Court will accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
No, Judge, we just got the stipulation of evidence, and so my client needs to sign that at this time.
Go ahead and do so.
There's no objection to states one as offered.
All right, stage one is admitted, and the court does take judicial notice of Mr. Mosley's judicial confession. Anything further from state?
Nothing further, Your Honor.
Any compliance with victim notification or victim impact statements?
Your Honor, the victim impact statement was sent out and never received in a couple of years, so we are in compliance.
Thank you, sir. Anything further from the defense?
Nothing from defense, Judge.
Mr. Manning, can you recite the stipulation of evidence for me?
Yes, Judge. It says on or about December 25th, 2020 in Van Zandt County, I, Justin Mosley, got into a fight with Courtney Shelburne. During that fight, I attempted to stab her in the leg with a screwdriver.
All right, thank you. Based on the evidence before the court finds that there is sufficient evidence to convict Mr. Mosley. Court follows the plea agreement today, convicts him of attempted aggravated assault with a deadly weapon. Third-degree felony, assesses his punishment at 4 years confinement in prison. Texas Department of Criminal Justice, the court orders a $100 fine, $290 court costs, $105 reimbursement fees. Court awards Mr. Mosley jail time credit of 1,069 days. Mr. Mosley, when you are released from TDC, you must report to the Van Zandt County Courthouse to make arrangements to pay your fine and court costs and reimbursement fees. Failure to do so will result in a warrant being issued for your arrest again. please step over and see the deputy be fingerprinted. You hereby remanded to the custody of the sheriff to carry out the terms and conditions of the sentence.
Hey, Judge, I just received some information on Mr. Orndorff. I could have just a moment to speak to him, and then we'll finish up the paperwork on Mrs. Moore, and then we should be ready to round out the rest of the day.
Sir.
Thank you, Judge. Mr. Hartwell. In noticing the time credit for Mrs. Moore, we appear to be a few days short. She was arrested on October 18th. And the judgment only has her with 33 days credit.
We'll take a look at that and get a corrected judgment.
She's been in custody in Van Zandt County the entirety of that time.
Okay.
Your Honor.
Yes, ma'am.
We're ready.
Okay, just a minute. All right, Mr. Manning, is this Ms. Moore?
This is Ms. Moore, Judge.
All right, Ms. Moore, if you will raise your right hand for me, I'm gonna place you on the oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you for lowering your hand. Your name is Samantha Maldonado Moore, correct?
Yes, sir.
Ms. Moore, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
I'm sorry?
Have you been diagnosed with any type of mental conditions?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done for you?
Yes, sir.
Do you feel like you've had enough time to talk with him about your case, that you've had all of your legal questions answered, and that you understand everything you've read and signed in your plea agreement?
Yes, sir.
Mr. Manning, do you believe Ms. Moore to be competent?
She is, Judge.
Can you explain to her the rights that came in this case?
I have, Judge.
Do you believe that she's entering into this agreement intentionally, knowingly, and voluntarily?
I do.
Ms. Moore, you are charged by information with a third-degree felony offense of possession of a controlled substance of group 1, greater than or equal to 1 gram, less than 4 grams. The range of punishment for a third-degree felony is sentence not less than 2 years in prison or more than 10 years in prison, and a fine not to exceed $10,000 if imposed. I see the plea agreement in your case is that you would plead guilty to that information and that charge. That your sentence recommendation from the state is 3 years confinement in prison, restitution of $746.05, court costs, reimbursement fees. It looks like the state would be dismissing 2 unfiled cases of failed to ID, fugitive, and also fraudulent use for possession of identifying information. And you would receive 33 days time credit for time against your sentence that you've already served. Is that your understanding, Ms. Moore?
No, I was understood that it would be 43 days.
43 days.
Yes, sir.
Yes, Judge, we had to make a correction on the judgment. She's been in continuous custody in Manzant County since October 18th, when she was arrested on this offense. And they corrected the judgment on our end, and it is showing 43 days.
Did you not say earlier that there was only 2 days at issue? Or did you say 10 days?
Judge, I said there was a few days at issue,
Oh,
and they returned with 43 is what they were showing as credit.
okay. And I could have just heard 2 days, so I was confused. Okay. All right. With 43 days credit now being given to you towards your sentence, is that your understanding as to everything else?
Yes, Judge.
Okay. All right, so Ms. Moore, at this time, I would ask you, how do you plead to, well, actually, I need to ask you this first. You are waiving your right to have your case indicted by the grand jury, is that correct?
Yes, sir.
So you understand that no one in Texas can be prosecuted for a felony offense unless the grand jury returns a true bill of indictment, or an individual such as yourself waives the right to a grand jury that says that they consent to the state prosecuting them by information. You understand that? And that's what you are wanting to do today is waive your right to a grand jury and allow the state to prosecute you on this legal form called an information. Is that right?
Yes, sir.
Has anybody threatened, force, or pressured you to do that?
No, sir.
You're doing that because that's what you want to do to resolve your case. Is that correct?
Yes, sir.
All right, the court's going to find that Ms. Moore has been admonished regarding her rights to waiver of indictment. She's intentionally knowingly voluntarily waived this. Mr. Manning, you joined in this for regarding that waiver of indictment, correct?
I have, Judge.
All right, of course, we'll find this. Mr. Manning has counsel Ms. Moore on that issue as well. All right, Ms. Moore, then, how do you plead to information on the charge of possession of a controlled substance, really group 1, greater than or equal to 1 gram, less than 4 grams, a third-degree felony? Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No.
Or accepts the defendant's plea of guilt? Mr. Manning, any objection to the stipulation of evidence?
No objection.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? Nothing further, Your Honor. Thank you. From the defense?
Rest of those.
All right, Mr. Manning, can you assist the court with the recitation of the stipulation?
Judge, I just handed it over, but I believe the stipulation stated that that Officer Milton was at the Eagle Parts Auto Store on an unrelated issue when he came into contact with my client. Upon coming into contact with my client, he asked if there's anything illegal on her person, and she offered up what was later determined to be methamphetamine. Lab came back as a testing 1.11 grams of methamphetamine.
Thank you, Mr. Manning. All right, then based on the, where did Ms. Moore go?
I think Ms. Moore. She got grabbed for a fingerprint a little bit early.
Sorry, we're not, my bad. All right. Ms. Moore, based on the evidence presented to the court finds that there is sufficient evidence to convict you of this offense. The court will follow the plea agreement you reached with the state. The court hereby convicts Samantha Maldonado Moore of possession of a controlled substance, milligram 1, between 1 gram and 4 grams. Court finds that she has waived her right to indictment and has been prosecuted on information. The court hereby assesses punishment at 3 years confinement in Texas Department of Criminal Justice. The court orders her to pay restitution in the amount of $746.05. The court dismisses under section 1245. DA numbers DA 2023-1135 and also DA 2023-1136. Court assesses court costs of $290, reimbursement fees of $15, and awards Ms. Moore $43 days to credit towards her sentence for the time that she spent in jail on this cause. Ms. Moore, once you are released from TDC, it's important that you report back here to the courthouse so that you can make arrangements to pay off your court costs, restitution, and reimbursement fees. Failure to do so is going to result in another warrant being issued for you. You go through the same process again. So if you'll just report, we'll make an arrangement with you to figure out what you can pay, and we'll work with you so you can stay out of jail. Okay. All right, Ms. Moore, you hereby remanded to the custody of the sheriff, so you have the terms and conditions of the sentence. Now you can step over again.
I got that over. Yeah.
Make sure he's got everything.
All right, Mr. Baines. Who's next?
Judge, next we have Mr. John Orndorff.
All right, John Orndorff, CR 1655, motion to revoke. Go ahead, Mr.
Judge, we have in this case discussed with Mr. Hartwell as well as with probation a tentative resolution for Mr. Orndorff's case. Unfortunately, we're waiting on one piece of documentation out of Dallas County to finalize that agreement, and we were unable to get it confirmed today before court. I received information from his attorney in Dallas that the case in Dallas County has been rejected and dismissed And that was the basis for the revocation. However, I've not been able to get a memo or anything official from Dallas County at this point in time. So we request that we have a short reset to December 14th, so that we can get that. And I think with that, we should be able to get Mr. Orndorff squared away and back on probation.
All right, the court will reset Mr. Horndorf for additional hearing and motion to revoke on December 14th at 1:30.
Judge, last but not least, I have Mr. Gregory Beaver.
All right, Mr. Beaver, you're on board. All right, this is cause number CR 22-87, State versus Gregory Holmes Beaver. Motion to revoke. Go ahead, Mr.
Judge, I was recently amended the appointment on 11/16 to include various other offenses. And I'm in the stages of negotiating with the state to get Mr. Beaver's all of his pending charges resolved. At this point, we've not reached a final agreement, so we request he be set out to the next contested docket. I believe the January 30th date. I hope to, at that point in time, be able to make a final announcement one way or the other regarding whether we need a hearing or we reach some sort of resolution.
Okay. All right, the court will set Mr. Beaver for the contested docket on January 30th. And the court will either, as you said, Mr. Manning, will either have a contested hearing that day or we'll have a resolution.
Additionally, Judge, my client has requested a bond reduction. I told him, he's requested that today. I've told him that I would file the necessary motions, and we may see if we can't get him in on a bond reduction on the December 14th date.
Yes, sir. Follow the motion and then we can set it and have the hearing.
Thank you, Judge.
You're welcome. Right, so just Mr. Lasser next. Last.
Yes, sir, and we'll head back that way.
All right, sounds good.
Thank you.
See you soon. All right, we are on record, cause number CR 20-258, State of Texas versus Jonathan Russell Lassiter. This is a continuation hearing of the previous hearing that we had on the state's motion to revoke community supervision. I believe that we met last on about October 26th. I received the evidence from the state, and the court had entered the pleas of not true to each count for the defendant, Mr. Lassiter. Court recalled the testimony of community supervision officer Stephanie Newburn. I also heard evidence from the defendant, Mr. Jonathan Russell Lassiter. Court has reconsidered the arguments made by Mr. Hartwell and also Mr. Hawkins in this matter. Court finds that on February 23rd, 2021, Jonathan Russell Lassiter was convicted of the offense of driving while intoxicated, third or more. That on that day had entered into a plea agreement with the state of Texas. Punishment, being convicted of that offense pursuant to the plea agreement, being punished at 5 years confinement in the Texas Department of Criminal Justice Institutional Division, along with a $3,500 fine. Court finds that the state filed a motion to revoke community supervision on August 22nd, 2023, and alleged in that motion 7 separate counts of various violations. The court, having heard the evidence, makes a finding that Mr. Jonathan Russell Lassiter has violated the terms and conditions of this community supervision. The court finds count 1 and count 2 to be proven by the evidence. The court finds count 3, count 4, count 5 to not be proven by the evidence, not true. And the court finds count 6 and count 7 to be true. Based on the court's findings of violation by Mr. Lassiter, the court next has time to consider the appropriate punishment in this matter. The court, having noticed that Mr. Lassiter has not been placed on the court's sanction program, had questions regarding that, and the court's finding that Mr. Lassiter has not been a part of the court's sanction court program to try to intervene when there are violations of community supervision, such that what Mr. Lassiter has had a positive or admittance of drinking alcohol. The court set forth with mind to sentence Mr. Lassiter Day to a rehabilitation program with the state of Texas, known as the Substance Abuse Felony Punishment Facility, hoping to intervene in Mr. Lassiter's life and give him a chance at rehabilitation for his addiction to alcohol. Unfortunately, the court finds that Mr. Lassiter has presented in a medical state that makes it very difficult for Mr. Lassiter to be part of such a program. Unfortunately, the types of medications that Mr. Lassiter has to be on and is on in order to combat his Crohn's disease prevents his participation in such rehabilitative programs. The court finds at this time it would not be in the best interest of the community for Mr. Jonathan Russell Lassiter to be placed back out in the community on the court's findings of violation of this community supervision. The court finds that it would be in his best interest for him to be sentenced to a rehabilitation program. However, the court finds that he's not an eligible participant due to his medical issues and the medication that he needs to treat his medical issues. That really ties the court's hands at this point. The court worked with the Van Zandt County Community Supervision and Corrections Department in reviewing Mr. Lassiter's medications, both here at the Van Zandt County Justice Center and with a report from Mr. Lassiter, and trying to find a way for Mr. Lassiter to be a part of that rehabilitation program. But unfortunately, the court has not found success in doing so. Therefore, the court is left with one available option, And that's the option that the board must pursue today. And that is upon the court's finding that Mr. Lassiter has violated the terms and conditions of his supervision. The court hereby revokes Mr. Lassiter's community supervision, assesses his punishment today at 3 years confinement in the Texas Department of Criminal Justice Institutional Division, orders that he pay the balance of his previous financial obligations, and that he received all credit time in which he has spent in jail on this cause prior to today. That is the order of the court. The courts in assessing this sentence has gone back and reviewed the original, the offense for which he was on community supervision, and that is the offense in which the court must and has assessed sentence today. The court also has taken into consideration testimony Ms. Newburn and Mr. Lassiter, finds that Mr. Lassiter in his admission to consuming alcohol in various states. That's why the court has granted leniency today to 3 years instead of the original 5 years that Mr. Lassiter agreed to. So with that said, that is the order of the court. I'd ask the state to prepare a judgment reflecting the ruling of the court, so that we can have Mr. Lassiter fingerprinted, and we can send that to the Texas Department of Criminal Justice. And it is within my experience to know that Mr. Lassiter will receive appropriate medical care at the Texas Department of Criminal Justice for his Crohn's disease and the medications that he's on. I hope that they'll continue his treatment so that he doesn't deteriorate at medical state. Mr. Hawkins, on behalf of Mr. Lassiter, anything else? Thank you. Mr. Hernandez, anything else on behalf of the state?
No, Your Honor, thank you.
If there's nothing further, then we're adjourned in this matter. Good luck to you, Mr. Lassiter.
Thank you, Judge.
All right, I believe that concludes the court's docket today. We are adjourned.